All right, next case we'll take up will be SCK Properties versus MAZOUREK. We're waiting. How much time do you want for rebuttal?
5 minutes.
All right, sir, you may proceed.
May it please the Court, my name is Steve Glashaw, and I represent the appellant SCK Properties. This is a case of first impression involving a statute which, to my knowledge, has never been interpreted in Florida law. Section 192.001, subsection 12. My position is that the issue in the case is whether a sign that is on the appellant's property is personal property or real property. My position is that the sign is real property. Therefore, no personal property tax return was required to be filed, and they were not required to have to pay a fine for not having filed a return. Their position is the opposite, that it's personal property, therefore you have to file a tax return, and it's appropriate to fine the appellant $7.88.
Well, let's talk about that for a minute. As I understand it, in whatever this county is.
Yeah, if you could speak up a little bit, I'd appreciate it.
Sure. The real property tax rates and the personal property tax rates are identical.
I think that's true in Hernando County, not true in every county.
We're talking about Hernando County here. And the only difference from your perspective with respect to whether or not this is treated as personal or real property is the fine that had to be paid because a tax return for personal property was not returned, correct?
There's the fine and also simply the requirement to file a tax return. Which
okay, and the fine was like $7?
Pardon me?
The fine was $7?
This particular fine, yes.
Yeah, okay. So what we're here about is a $7 case.
I think that it's a very large case, but as to that specific issue, yes.
Okay. Now, let me ask you...
And change.
And change, I'm sorry, yeah. Let me ask you about whether ownership of the sign is critical to how it's taxed.
I don't think that it's critical, but certainly in this case, the ownership of the sign and the ownership of the property are the same.
Well, suppose the ownership of the sign was with a sign company and the ownership of the property was with your client. Would it have made a difference on whether or not it was treated as personal property?
I believe it would not have made a difference, but I can see an argument that it did. Certainly the Attorney General seemed to think that that made a difference. In the Attorney General's opinion, I cited.
Yeah. Now, suppose there were two signs on the property. One of them was owned by your client, and one was owned by another person. Would it make any sense for one sign to be treated as personal property, let's assume they're identical signs, one to be treated as personal property and the other to be treated as real property?
Well, I mean, I think that they should both be treated as improvements and therefore real property, but there's an arguable distinction there in that since the ownership is different, there's not the sense of permanency that might be the case because the two are the same, owned by the same person.
Yeah, because I mean, you could always, no matter how it's attached to the earth, you can always disassemble a sign, right? Yeah. Even if it's sunk in concrete, you can still take it down.
All right.
Well, let me ask you this. In your brief, you cite to various statutes and various cases that give a definition for real property. What are the controlling definitions in this case, both as to real property and personal property?
Well, the Florida Supreme Court, I mean, there isn't any definition. The legislature has not defined the word improvement, which is the key word in the statute. for purposes of tax.
Well, before we get to improvement, how about the definition of real property? Is there a statute that says for purposes of taxation, real property is this?
The definition of real property is the statute we're talking about, 192.001 sub 12, which is that real property includes land, buildings, fixtures, and all other improvements.
All right. Now, 192.11d also defines tangible personal property, and 12 defines real property. Can an article meet both definitions?
No.
You think it has to be one or the other?
The definition of personal property is, in 11D, is an article which is capable of manual possession and a chief value is intrinsic to itself. And the nature of a article is that it has an independent substance. Once something becomes incorporated into something else, such as an improvement, then I think the concept of this statute implies and seems to say that it's no longer an article, it's no longer an independent thing, and instead is an improvement which is incorporated in the property, in the main real property.
All right. So it's your position it can only meet, they're mutually exclusive. If it's tangible personal property, it can't be real property and vice versa.
The statute wouldn't make sense if they weren't mutually exclusive. And what happens is most things start off as personal property, and then as they are incorporated into land, become part of the land, they're no longer personal property, they become part of the real property.
All right, let me ask you this. Is this sign, is this chief value intrinsic to the article itself?
Absolutely not.
You think it's only worthwhile if it's, as it benefits the land?
The primary function of that portion of the statute is to distinguish it from intangible personal property, which the value is not intrinsic to itself, but rather what it represents. But as to that language itself, if the sign was in a swamp somewhere, it wouldn't be worth anything. If it was in a residential area, it'd be worth something more. If it's on a busy street, it's really worth a lot. So the chief value of the sign is where it is, not what it is. And
what if the sign is for the benefit of not the property owner on the property where the sign's located? For instance, you had two businesses, one's on a main street and one's off the main street, and the one off the main street gets permission to put up a sign from the property owner who's on the main street and says, Joe's Deli around the corner or down this driveway. Is that a value to the real property itself, or does that sign have value in and of itself?
It has some value. I'm not saying it doesn't, but the chief value of the sign is what it points to. And in that case here, it points to these businesses that are there. And frankly, if viewed in itself, it's an old sign. And to take it out, if you try to take it out, it'd probably destroy it. So it's just not really worth much by itself. What its primary value is to the businesses that are there, and the people that see it know that they're there.
Do you think this sign is capable of manual possession?
Well, that depends on the definition of manual. If you're talking about manual in the sense of manual dexterity.
That's just what the statute says. Personal property has to have those two elements, capable of manual possession and chief value is intrinsic to the article itself.
I think that the purpose of that particular phrase is to distinguish it from intangible personal property, which is not capable of manual possession.
Do you think there's ambiguity in the statutes?
The statutes could be clearer, yeah, but I think they're clear enough. I don't think there's any ambiguity in the sense that there's no doubt the sign is an improvement, and if it's an improvement, it's real property under the statute. And the appraisers admitted under oath that the sign is an improvement, and the appraiser admitted under oath that the sign is real property. And now the attorneys are saying that was irrational testimony. Now, it must be a first in Florida history that the defendant admits under oath that the plaintiff is right and that the plaintiff loses anyway. So, getting back to the definition of the statute, the statute says that real property is land, building, fixtures, and all other improvements. And focusing on the word improvement, there's no definition in the statute as to, for tax purposes, the way we've looked at, as Florida law requires, look at dictionaries and other definitions. And those definitions generally say that something is a improvement if it's attached to the land for its permanent benefit. And here's a sign of attached to the land. It's cemented in there. You need a crane or a jackhammer to get it out of there. Been there since 1989, 19 years, soon to be 20 years. Provides a benefit to the land, therefore it's clearly an improvement. And just as a matter of common sense, you look at it, it's obviously an improvement. And so for them to say, they don't really deny that. They admit that it's an improvement. It's undisputed actually that this is an improvement.
What do you make of the Department of Revenue's rules associated with this?
I'm sorry, say
What do you make of the Department of Revenue's rules which require assessors to treat signage as personal property?
Well, needless to say, I think the guidelines are incorrect. If you look at the guidelines, there's a lot of things about the guidelines that don't make sense. I mean, they say that cooling towers are personal property, but cold storage buildings are real property. They say that electric power plants are personal property. They say that security fences are real property. A fence is real property. There's a fence on that property there that we're talking about, but the fence is real property, but the sign is personal property. How could that be? The security fence is real property, and yet a security gate is personal property. So you have a fence around the building and a gate to let people in. The fence is real property. The gate is personal property. It doesn't make sense.
How about a sign that is just nailed into the building? You know, there's a chain over it, and they put a nail in the wall, and they put the chain over the nail, and you got a sign hanging up. Is that personal or real?
Well, I think that some signs, you can have signs that are just hanging in a window. You can easily remove them. They're not permanently there. Those kinds of signs would be personal property, yes. I mean,
All right, so does the tax assessor have to examine each sign to determine how difficult it would be to remove it?
That's the assessor's job. The assessor's job is to determine whether something is an improvement or not. So if that's what's required to determine whether it's an improvement, then the answer is yes.
All right, so your position that sometime the sign becomes so affixed, the manner in which it's affixed to the building or the property, at some point it becomes an improvement and no longer is a personal property.
That's right. I mean, you could have a sign in a window. You can buy them at Sam's Club that says "open," and has a neon light goes off and on. You take it. That would be a personal property. To give some of these other examples, I mean, they say that a septic system, which I assume is septic tanks, is real property. Yet they say that gasoline tanks at a gas station are personal property. What's the difference between a septic tank and a gasoline tank? I don't get that. I mean, these guidelines just don't make sense.
Come to the break after the third case, and we can explain that to you.
Okay, thanks.
Let me ask one other thing. If the sign is attached to a pole and the pole is not cemented in the ground, the person just digs a hole, sticks the pole in, puts the dirt back around it, not too stable, but is that enough to become real property?
I mean, if the sign is not cemented in the ground, it's just the pole is there, it's not cemented in, it's just how would it stay up?
Well, if you dig it deep enough and put dirt around it.
And dirt. I would say that's, if it's been there long enough, then I would say that's sufficiently attached, yes.
So why does time have anything to do with this?
Why does time? Well, all the definitions of improvement have a sense of permanency. If it's just there temporarily, then it's not an improvement. So time makes a difference. I guess in a certain sense, nothing is permanent. I mean, the periods of Egypt are not permanent. But as long as the case law says that as long as it's been there long enough, that's good enough. Now
Does that mean that a sign could theoretically be put up and for the first year or two it's a personal property, but then when it hits the third year it becomes real property?
I guess you would have to include some element that you put it there with the idea that it's going to be there a while.
It's a matter of the owner's intent. How does the appraiser determine that?
I think that you just look at it and say, you look at the sign, you say that that's reasonably expected to be permanent. If this particular sign is cemented in, there's no intention that anybody is going to take it out anytime soon. The appraiser in the brief talked about fixtures, and I don't think that it's necessary to get into fixtures, but fixtures are real property also, but if you want to go there, we can go there. I mean, fixtures are defined to be affixed to the land, appropriate to the use, and then you look at the owner's intent. Well, the sign here is attached to the land. It's appropriate to the use of the land, and the owner's intent here is completely undisputed. The appraiser doesn't really dispute any of this. And what the appraiser really argues in the brief, and I'll look at the first sentence here of the summary argument, determination of whether property to be classified as real or personal property cannot be made solely by reference to the definition in Florida statutes. And then if you look at page 8.1a, Florida statute does not determine the classification of property for assessment purposes.
All right, you're 5 minutes.
So the appraiser's argument is he doesn't have to follow the statute. If that statute don't determine it, it's right here in bold print. Florida statute does not determine the classification. And that's essentially what the trial judge ruled. I mean, my argument was, even though the guidelines say that the signs is personal property, that contradicts the statute. Therefore, you can't follow the guidelines. And the trial judge's ruling is, well, I'm going to follow the guidelines, and so the alternative would be chaos. But that's not a valid reasoning. I mean, black letter law, administrative agency does not have the authority to disregard the plain meaning of the statute. The plain meaning of the statute here is that the sign is an improvement, therefore it's real property. You know, and the thing about these guidelines, they're so arbitrary. I mean, I think about, suppose I put a post in the mailbox. Is the mailbox like the sign? I mean, and therefore personal property? Or is it like the fence that's there and therefore real property? I don't know. I mean, how do you figure that out? Or if you say you put a palm tree there right next to the sign, is a palm tree like the sign, therefore personal property, or is it like the fence, which is real property? These guidelines are so arbitrary. What you need to do is follow the statute. The statute says you look at whether it's an improvement or not. If it's an improvement, then it's real property. That's the end of the matter. Now, I'm running out of time. I had hoped to get into some of these procedural objections. I don't know if the board has any questions about those.
All right, you have just a little over 3 minutes for rebuttal.
May it please the court. I'm Gaylord Wood of the firm of Wood & Stewart. Linnell with me is my partner, B. Jordan Stewart. And we represent the appellees in this case. There's ALVIN, MAZOUREK, the Hernando County property appraiser. I have been representing property appraisers for 40 years this year, and this is the first case in which a taxpayer has come before a court seeking a tax increase. And the reason for this is the voters recently passed an amendment to the Florida Constitution, which is effective for the first time this year, and it exempts tangible personal property of up to $25,000. So because the tax rate is the same for both real and personal property, if Mr. Crochelle were completely successful in this case and had by the way, this is his limited liability company. His client is Mr. Crochelle. If he were completely successful and this sign were removed from the tangible personal property roll, the property appraiser would make a back assessment and place it on the real estate roll. Doing a back assessment is permitted by the statute, and his taxes would go up because
does that help us make the determination as to whether it's real or tangible personal property?
Well, it really doesn't matter because the tax rate is the same. The affidavit of Mr. King, which was submitted, paragraph 9 of that affidavit makes it very clear that there was no value attributed to the sign in the real estate assessment. And Mr. Crochelle makes a double tax argument in his brief, which is absolutely unsupported by the record. It's as nicely as I can say it. It's crystal clear. We have the property record card for the real estate in which there's no mention of the pole sign.
Let's start talking a little bit of law, if you don't mind. Looking at the statute, you've taken the position in your brief that the statutes aren't what we should be looking at. The property appraiser shouldn't go by the statute. The property appraiser ought to look at the Department of Revenue regs. Why isn't the statute controlling?
The statute does control, and the regulation is completely consistent with the statute. In other words, there are, because...
Do you believe that this sign falls under the definition of tangible personal property?
Absolutely. And
then let's read it and see.
Capable of manual possession.
Okay, and how is this sign capable of manual possession?
If you look at the picture of it, which is in the, it's an exhibit to Mr. King's, it's Exhibit 4 to Mr. King's deposition. It's an illuminated box sign. It has slide-in panels, one of which mentions the tattoo parlor. There's one for an Epicurean restaurant. There's one for a tax service. All right? If one of those tenants leaves, one can simply slide the panel out. It's an illuminated box sign. There are lighting
It's a monopole sign that's cemented into the property.
And the sign itself is held in place by a blob of cement. Now, the fact that a person cannot lift it does not mean that it is not capable of manual possession. The case law that we have cited involves things such as an elevator in an 11-story building. There is a water and sewer plant that where the pipes are all
Let's say that
underground.
you've got a piece of property that abuts a highway, and so you lease out to an advertising company one of the large signs. It's a monopole sign. Is that real or is that personal property?
Tangible personal property. I mean, it weighs tons. It would take several large cranes to mount it in position.
All right. Suppose you have a building, and this building, and instead of putting that sign up, they paint on the side of the building what each of the tenants are.
Real property.
That's real property.
However,
now wait. Suppose you get a wall just as big as the wall that you painted that on, and you stick that on the property, stick it in a foundation in concrete, exactly the same as the wall that you had before. Does that now become personal property?
I would think so. I would think it...
So just because it's not attached to the building,
right,
it's now become personal property?
I would think so.
Is there some sort of weight limitation on this?
No. But the term capable of manual possession does not necessarily mean that a human can lift it. Every one of these light poles...
What does manual mean?
Sir?
What does manual mean?
Manual...
Doesn't that come from the Greek involving hands?
It does. Yeah. The root of it is from the hand, but the term does not... There is no court has ever said that the limit of personal property is whether you can lift it. For example, every one of these light poles up and down Beach Street, owned by Florida Power and Light, they are on the tangible personal property roll. They are probably affixed into the soil as firmly as Mr. Crochel's signboard.
I hope so.
I hope so. But and to answer Judge Evander's question about can something be both, I think it can. And the example I would give you would be a bathtub, where in the showroom at Home Depot, it would be inventory or stock in trade. If you take the same bathtub to your house, you live out in the country, and the kids' 4-H cows drink out of it. You have it in the backyard. It's household goods and personal effects. Both of those categories not taxable. You take the same bathtub and move it out in the pasture where your commercial cattle herd is, and the same bathtub is now tangible personal property. And then if you took the same bathtub and placed it in your house in a bathroom, grouted it in, it would be a fixture and taxed as part of the real estate. It's the same object.
Well, let me ask you this. How do we track these two definitions? We have a definition of 11D for tangible personal property. We have a definition in paragraph 12 for real property.
Yes.
Do we start with real property and say, this is a fixture, or this is improvement to land, end of story, appellant wins? Or do we start with tangible personal property and say, this is capable of manual possession, its chief value is intrinsic to the article itself, end of story, appellee wins?
Well, I think you look at both definitions, and the Department of Revenue, I certainly wish they were in this case to defend their guideline. Mr. Crochelle didn't sue them, but what he's doing is attacking the administrative agency that has the responsibility of enacting reasonable regulations for the guidance of property appraisers, and where they have their interpretation, which the courts give great deference to the administrative agency in charge of a particular aspect of government. When this agency says signs are personal property, it's a very practical solution. Because
does your client have any discretion but to follow those regulations?
Well, when we didn't, we had this court decided the Scripps-Howard case, Scripps-Howard versus Havel, where the property appraiser did not follow these same tangible personal property guidelines, and you struck his assessment.
Well, but is that because it was contrary to the statute? Or
No,
because
it's contrary to the guidelines. You mentioned these tangible personal property guidelines, so should not the opposite be true, that if the property appraiser does follow the administrative guidelines, that's not a reason to set aside his assessment?
Well, the Department of Revenue has no legal authority to amend the statute. There's unambiguous language in a statute, do they?
Their authority is in 195, Chapter 195, and they have specific authority to enact regulations. And
that wasn't my question. My question was, do they have the authority to alter the unambiguous language in a statute?
No. I don't think they do. But as I said, in this case, the case that's before you, it actually makes no difference whatsoever whether this sign is assessed as real property or as tangible personal property, because the tax rate is the same.
What about the burden of having to file another return?
Mr. Crochelle is a CPA also, as well as being a lawyer, and I assume...
Well, we're not talking about just Mr. Crochelle here. Suppose
we file returns all the time. And I would point out one thing...
That's not the question. The question is there an additional burden placed on the taxpayer to have to file a second return? And does that qualify as damages?
No, it's not damage, and it's not a fine if Mr. Crochelle keeps using the word fine, and it's not a fine. There's a statutory penalty of 25% if you don't file the return. And on a $1,000 sign, the penalty was, the penalty was $7. So if your time is worth $7 not to file a return, you don't file the return. But one of the things that I would point out, though, that's in our record that's very important here is for 18 years, this sign was taxed and returned as tangible personal property by Mr. Crochelle's predecessor in title. And he also got a bill of sale to it. You don't get bills of sale to real estate. And so since he got a bill of sale to this sign, it would seem that its characteristic as tangible personal property had been long established. And I think that's an important consideration. There is a possible statewide impact here, which is if the court rules that signs just by their nature are, quote, an improvement, I can see chaos, just as Judge Tombrink did, being created in both the field of taxation. For example, your case where the owner of land and there's a billboard, one of these huge highway billboards, if that's declared to be real property, what about the situation where the sign company owns the billboard, The landowner owns the land, and you're now directing that the tax bill for the signboard goes to somebody who doesn't own it, who owns the real estate. I can see that as being a difficult situation. And then there's the other situation.
Well, does ownership of the sign play a role in this?
I think it does. I think that in the situation where party A owns the land and party B owns the sign, then you get to the law of fixtures, which is the intent of the party affixing it to the real estate becomes important.
Well, suppose the owner of the sign and the owner of the land are the same person, as we have here.
I think it's simply a factor. But looking at the sign itself...
If there's no practical difference in terms of the tax, why doesn't the taxpayer get the choice of returning it as one way or the other if he owns the sign?
I think it's not the taxpayer's call. I think it's the property appraiser's requirement of uniformity to assess all the signs in the county one way, which is what he does. In fact, all 67 property appraisers in the state of Florida uniformly assess all signs as tangible personal property. So, and then there's one final aspect.
Based upon the DOR reg.
Yes, that's correct. And one final aspect is a declaration. You have to be careful what you ask for sometimes, because the law of unintended consequences kicks in. And one of the cases we cited was a criminal case where there was a large mural that was affixed to a building. And the thieves came in and they pried the mural off the building, rolled it up, and made off with it. And the court, the defense was it was real property, and therefore I could not be guilty of larceny. A declaration, and the court just said, well, it wasn't. I guess it wasn't affixed that hard, and they didn't have any problem upholding the conviction. But you can't have larceny of real property. So if someone were to steal one of the panels out of Mr. Crochel's sign,
but something can be personal property for one purpose and real property for another purpose.
Of course, the statute, the larceny statute, has been interpreted as saying that it only applies to personal property. There's no such crime in Florida as larceny of real estate.
Now, in the deposition,
Mr. King,
there were a number of questions asked, and I think basically what they did was they tracked the statute, and they talked about whether it's fixture, whether it's an improvement, and the witness acknowledged affirmatively to each one of those questions. And your response in your brief is, well, he was simply responding to the question asked. Amplify upon that a bit.
we have two responses to that. Number one, this was not an agency deposition of the property appraiser's office. This was a deposition of Mike King, who appraises tangible personal property and has no responsibilities whatsoever relative to the appraisal of real estate. That's not what he does. And so Mr. Crochel's questions, well, wouldn't a sign improve real estate? And his answer was, well, sure. But he was not speaking as a representative of the office. And when you look at it, and we outlined, in fact, we put in at page 3 of our brief, where he said that Mr. King admitted it was real property, so the sign is real property. Well, I guess it's an improvement, but the fact remains, Mr. King has a responsibility to follow the Department of Revenue guidelines and the rules and regulations. They're in the Florida Administrative Code. And so if Mr. Crochel's problem is with those rules and regulations, he should be bringing an action against the Department of Revenue in the circuit court in Leon County to set aside those regulations. And the Department of Revenue, they're not in the case. So I think there's an indispensable party missing as far as an attack on the guidelines.
Well, typically that's raised at the lower court level.
Sir?
Typically we'd like that raised at the lower court level.
So, thank you.
Thank you.
The appraiser raised a number of things were not mentioned at all. I've heard them for the first time just now, about the Constitution. That was never raised below. Talking about the bill of sale, that was never raised below. Judge Cohen pointed something out that was never raised below. So a lot of what he says is not raised below and can't be considered by this court. Essentially, what the statute says, again, is that, real property includes land, buildings, fixtures, and all other improvements. What the appraiser wants to do is insert the word "not" there several times, so that real property includes land, comma, not all buildings, not all fixtures, and not all improvements. You can't add the word "not" to a statute like that. The administrative agency does not have that authority. One thing that didn't was you relied on a lot were so-called national sources like the Green Book. I have yet to actually see those. There's not, what I was shown, nothing said that the Green Book says that the personal sign should be treated as personal property. And more importantly, those national sources don't address what the statute says. And here we're applying the statute. And what some other source may apply in other states, it doesn't really matter. I don't really have time to get into the procedural things. I did want to point out the Tort Claims Act, which was raised by the appraisers, again, for the first time on appeal. I didn't even know what that statute was until I saw it in the brief. This court has said that you can't raise something like that after a judgment is issued. And I think the Tort Claims Act applies to torts. It doesn't apply to a tax case. We've got a separate statute that says a procedure for tax cases. Now, I don't have anything else if you have any questions.
Thank you.
Thank you both.
Interesting case.